Environmental considerations are increasingly becoming a hot topic when it comes to land development in Western Australia. Section 38 of the Environmental Protection Act provides for a significant proposal to be assessed. Of course, this then overlaps with the federal legislation being the Environmental Protection Biodiversity Conservation Act. This can then result in some significant argument and contests in respect of what is a significant proposal and what is the nature and extent of the assessment required.
Wetlands have significance in Western Australia. In 1971, the Ramsar Convention identified certain wetlands as having international significance. Here we are at Forestdale Lake. This is one of those very significant wetlands. There are certain characteristics of land that determine whether or not they are properly to be considered as a wetland. When mapping was originally undertaken in the mid-1990s, areas of land were identified as having wetlands based on aerial photography. What is required today is ground truthing to determine whether or not the area is truly to be considered a wetland. For that reason, it's important to undertake site-specific studies by an environmental scientist to properly determine the extent of any buffers to a wetland. The extent to which a wetland is going to require a buffer depends on the environmental characteristics. Different wetlands have different considerations. A basin wetland, which is found within the middle of a paddock, for example, will have a different consideration to a riverine wetland. They, in fact, have different policy considerations that are applied to them. Therefore, different setbacks. The question that needs to be asked is, what is the extent of the buffer that needs to be applied to protect the environmental significance of that particular wetland? Applying a generic buffer is not the appropriate way in which the wetland is to be protected. In some instances, it is appropriate to have a setback of just say 5 or 10 metres from the fringing vegetation of a wetland. In other instances, a larger buffer is truly required. And this is where a lot of the arguments occur. What is the true nature and extent of the buffer to a wetland that is required to protect the characteristics of that particular wetland? And that's where lawyers become important. As lawyers, we're often asked to consider conditions imposed on a subdivision or a refusal of a development application made in proximity to a wetland. That's where lawyers consider the policies and whether or not the condition is truly required to be imposed as it is, with a setback to a wetland, or whether the wetland has the characteristics such that the development or the subdivision ought not to proceed in proximity to that wetland. Just because a portion of land is identified as regional open space doesn't therefore mean that the land cannot be developed at all. And it's on the question of whether or not the land is able to be developed that there is a lot of debate and a lot of argument when it comes to an assessment of the true amount of compensation to which a person may be entitled if their land is identified as regionally significant. So there are different categories of wetlands. There's a category conservation wetland, there's a resource enhancement wetland, and the extent to which a wetland is considered to have conservation significance requires a careful and detailed study to be able to show whether or not that's truly a conservation category wetland or whether it's one of the other types of wetlands. So there's been a lot of work done, a lot of science put into identifying land as wetlands. There's been a lot of policy that's been developed to prevent development over areas which are wetlands, and there's been a lot of work done by way of planning policy, environmental policy, planning considerations to ensure that wetlands are properly and adequately protected through applying buffers, through constraining development. So in the 1970s and 80s, there was a lot of easy land which was developed. All of the easy land in Perth is gone. The hard land now has to be developed, and that's the reason why we're looking at ways in which we can apply science to reduce buffers to wetlands, to prevent nutrients from flowing into the wetland from the adjacent development. So what we're doing now is identifying whether or not that wetland has been properly mapped as either a conservation category wetland or a resource enhancement wetland. And we're looking at the ways within which we can ensure that the environmental characteristics are not compromised by surrounding development, be that subdivision or be that by way of the construction of some other form of development in proximity to that wetland.
If you have land which has been identified as an area of environmental significance, or if you have a development which has been refused due to environmental constraints, we have a team of lawyers at Cornerstone Legal who not only have the knowledge but also the experience to be able to guide you through the steps and the processes required to ensure that we get the best possible outcome for you and your land.